Welcome to Remax Boulder's video podcast. Today we have Gina Weinberger with us. She is with Weinberger Law and affiliated with Remax Boulder. Today our topic is about security deposits. And first of all, Gina, thanks for being here today. Appreciate you being here.
This is great.
Security deposits on rentals is kind of a big topic in Boulder because our housing stock in Boulder is about 50% rental. And we have a huge mass of college students that come and go on a yearly basis. So it's a big deal talking about security deposits. So our topic today is just that. And it's timely now because a lot of the kids just moved out August 15th and now they're got to be getting the deposits back now. So what is a security deposit? There's a lot of misconceptions, I think, of what it is.
Right. So a security deposit is an advance. So it's a certain amount of money that's collected to assure that the other party performs under the rental agreement. So as a landlord, when you select how much to collect as a security deposit, you should be thinking, well, what kind of damage can happen to this property and how much should I be collecting ahead of time in case there is damage?
And so what can it be used for?
So a security deposit can be used for basically anything to assure that the other person complies with the lease. And the statute on this, so there's actually a state statute, the withholding statute, and it defines what it can't be used for a little more clearly. So it can't be used for usual wear and tear, the normal wear and tear. And that's the impact on a property resulting from using it how you're supposed to, right? So if the carpet's a little bit more tracked than it was when they moved in, that's normal. If it's torn up, that's not normal, and so you could use a security deposit to fix that.
Okay, and then what is it not? I know there's a lot of confusion about security deposits versus rent. How does that work?
Right, so a security deposit, and this should be outlined always in the lease. You should say the security deposit's maybe 1 month's rent. Spell out how much that is. And I think some of the confusion you're talking about is when, in addition to a security deposit, landlord also collects the last month rent. And that's because, sometimes tenants think, well, they've already paid so much money as a security deposit, they don't have to pay the last month because the landlord can just take it out of that. That's not really what it's intended to be used for. And that's why more and more landlords are collecting in addition to a security deposit.
Like first and last month's rent up front.
Right.
But there's no rule or statute relative to what they must do or the amounts. It's all market driven, is that correct?
That's correct. Some states, there are very set limits on how much you can collect as a security deposit. But no, here in Colorado, it's all market driven.
Okay. And what about time? When does the landlord have to get a deposit back by?
Right. So the statute says 1 month, although the parties can agree to extend that to 60 days. So it's 30 days if the lease is silent, and then they can agree to extend it to 60 days, which is why, it being October, it's a particularly relevant topic right now.
Okay.
Everyone's getting their security deposits back.
And once that tenant hands over a security deposit to the landlord or property manager or the owner, where's that money typically held?
In Colorado, individual owners they don't have to keep a separate account. The rules are a little different for property managers, those making a living off managing other individuals' property. But again, you should keep that sum safe because think of it sort of as money you're holding on to ensure the other person perform. It's sort of like a trust account. So it can be mixed with other funds, but make sure you hold on to it until you have done an accounting.
All right. Well, tell us a little bit about the process of returning a deposit to the tenant. How does that happen? And then I know Boulder's got some specific rules about that as opposed to some other communities in town.
Right. And so this is where the security deposit wrongful withholding statute really kicks in and gives very clear guidance on how to return a security deposit properly. So first of all, it should be sent to the tenant's last known address. It should be sent within that time period. And you need to give a very clear accounting as to what's being withheld or retained and why. It is also important to remember if you're in Boulder, at least in the city imposes an interest. So landlords have to pay interest on the amount on the security deposit. And that's based off of the average of a 1-year CD. So right now it's really low. It's like 3.16%.
So the paperwork part of it could be more valuable than the interest itself, it sounds like.
Yeah.
Now, if withholding does occur, like let's say there was a reasonable reason to withhold half of it, what's the interest get paid on the whole deposit or just the amount that was retained?
It's the whole deposit, and it's based off a monthly calculation. So for however long you held it. So if you've held it for a month after the end of the lease, you have to also include that month when you're calculating interest.
And what happens if the landlord fails to return it to a tenant in a timely manner, as opposed as in the 30 or 60-day requirement?
Right. So failure to either return it as they ought to, or failure to just give an accounting. So maybe the landlord thought there were actually damages on the property, so they kept the whole deposit. And they might have been right to, but they failed to give a accounting explaining what that money was used for. Then you're in serious trouble. After the 30 or 60-day deadline, whichever one you're working off of, the tenant then has the right to give you a 7-day notice saying that they're going to sue you for their money. And at that point, failure to give a statement or return the security deposit as you ought to have results in a complete forfeiture of the security deposit.
And how is that enforced?
And so that's enforced by allowing the tenant then, after those 7 days, to go to a court, and if they succeed there, then they win treble damages, so 3 times the amount.
Okay.
And you can probably gather why it's such a severe consequence, because the weaker party is the tenant, usually. They're the one trying to get their money back. So the state legislature said, well, we're going to shift it a little bit, and we're going to shift the burden from, make it a little bit easier for the tenant, give them a little more leverage. And so there's a court case, Michigan v. Young, that explains very clearly how this works. And explains how serious this is for landlords for failing to do as they ought to under the wrongful withholding statute. So in this case, the court explains, look, if a tenant sends you a 7-day notice, you have to give back the entire security deposit. You've lost your right to use it. That 7-day period is like a grace period, because if they actually have to go to court to enforce their rights, then you're facing treble damages and attorney's fees and court costs.
Okay, and treble is 3
times.
Okay.
Yeah.
And when the coin is flipped, from the landlord point of view, what if the damages far exceed the security deposit? What does the landlord have to do to try to collect that?
Well, then the landlord's in a tight position, because then they're going to be pursuing in a separate action the tenant and trying to collect, through the more traditional route. And that also can be very difficult, which is why we ask for security deposits ahead of time.
Anything else you can think of that you'd like to add?
One thing I think is important is to know that this wrongful withholding statute, you can't contract around it. So you can't make someone give up their right to get a security deposit back, or you can't contract beyond those 60 days. The legislature's been very clear that this is intended to shift some of the power to tenants, and so it's been interpreted that way.
What's happens in the marketplace on the 30 to 60 days? The statute says 30, unless agreed upon at 60 in the lease. What's kind of the norm that you see? Is it mostly 60?
It's almost always 60.
Almost always 60. Interesting.
Yeah, because you want more time especially for big property management companies. They have to go through so many units.
Takes a while
August,
to process
so they want that extra time, and it's very common.
Yeah. Okay, Gina, thank you. Appreciate you being here. There's a lot of great insight for our customers and clients. Duane Duggan, RE/MAX Boulder Video Podcast, signing off.